lane changes and had an expired registration and visited them the lane several times. A traffic stop was initiated. An officer observed defendant to have chewed the eyelids and glossy paint. Officer also observed the moderate odor of alcoholic beverage from defendant's breath. Standards of sobriety tests were conducted. 6 out of 6 HGN, 5 out of 8 walking tonight, and 2 out of 4 wetland stand. A breath sample was provided and results were 0.108 and 0.100.
Does he have any DWIs? Does he have a license?
No provision on their number means license right now.
Okay. Mr. Dyke, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, then I will revoke the bond, put you in jail. No more PR bonds for you. This is not a revolving door. Do you understand? Sir. How old are you, sir? Do you have the ability to hire a lawyer? Yes. How do you support yourself?
Work at the server, restaurant.
Okay. Deputy Williams will give you an application. I need to know how much money you have coming in. I need to know other household income, and I'll take a look to see whether you qualify. You're not allowed to drive unless you have a valid Texas driver license and liability insurance. You must maintain car insurance. If you don't have it, then likewise, do not drive. You understand?
And Your Honor, his license is eligible.
Great. All right. We'll have you fill out the application. You'll meet with Ramona. You'll sign conditions of bronc, and then we'll have you take a seat, sir. Hi. Good morning. Are y'all splitting again?
Over to Sean's case, Mr. Chair.
So the beginning, you got the end. So, okay, cool. Easy to remember. We're talking about this. Mr. Harry, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On May 25th, 2026, officer was dispatched to residence and met with complaining witness who observed the defendant at her residence. Complaining witness stated the defendant had been on her property approximately 3 times and had been invited by the witness without complaining witness's consent, and she stated she is the primary owner of the property. Officer observed the defendant sitting in the trunk of the vehicle that was in the complaining witness's residence driveway.
Sitting in the trunk.
Yes. That's what I have in my items. The defendant stated he received a ride from a security guard to the above residence to get some of his items that the witness had in her bag. The defendant stated he does remember receiving a warning, but believed it to be a warning of not returning because of disturbance.
Do you know the relation? Is there any at all? Or no?
Can you repeat that?
Is there any relation there? Do you know?
I believe that the witness is the daughter of the complainant.
Got it. Okay.
And was dating the defendant.
All right. Mr. Harry, I'm going to find that there's probable cause to go forward with your case. Your only condition is to not go back to this house. Do you understand? I'm not asking much from you, really. Just don't go back. You can meet somewhere else. Just really. Do you have the ability to hire a lawyer? What do you do for a living? Okay. We will give you time. I'm going to have you sign a reset, and then I'll have you take a seat while we get bond conditions. Come to court. Don't wear shorts. It's a complete sign of disrespect. I mean, really. This is a courthouse. You're not going to... You understand? Yeah. Okay. Please. Oh, I'm sorry. If you can file conditions, please do not go back to the house.
Okay.
Please.
Megan?
Yeah, I got it. All right, Ms. Liggins, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
May 25th, 2026, officer was dispatched to an apartment complex in reference to an assault occurrence/injury. The officer observed a blood trail from the lobby to the parking garage, where the officer found the defendant's size storage closet covered in blood, and there were cuts on the defendant's hand, right leg, and feet. Defendant stated she had a fight with her boyfriend at his apartment, and he had pushed her twice to get out of the apartment, and she had knocked over a candle, which is what caused injuries. Officer then met with the complaining witness, who stated he and defendant were at a pool party and are dating. Complaining witness grabbed his cell phone that the defendant uses and saw that the defendant was texting other men. Complaining witness left the area to get picked up by a friend, and complaining witness and defendant got into an argument, and he found his vehicle to be destroyed and believes the defendant is the one who did it. The officer observed damage to complaining witness's windshield, smashed multiple times, kicked in one side, and driver's side window broken. And the officer observed blood on the vehicle's hood and on the passenger window. The officer concluded the injuries defendant sustained were from damage from the vehicle.
You've got A and you've got C, but you don't have B. Does anyone see her do it? Do you have video doing it? Do you have a kind of blood sample that shows it's her that did it? Did the officer take the next step to see if there's video inside the parking garage?
That I'm not sure about. It does say here complaining witness said he and his friend drove to his vehicle after the argument, and that's when he found his vehicle to be destroyed, but I do not have any other indicators of it.
I need more. It's just not enough. It's assumptions, hunches, and I get it, right? Car's destroyed, it's got blood on it, she's covered in blood, but do you have anything else? Sure. Mr. Bell, your client has a bond violation. Hall. Tiara Hall. Is she here? She's supposed to be here. Okay.
Monitoring is the officer observing the damage to the vehicle and observing the injuries that the defendant had.
So, Miss Liggins, I mean, pull up the OR if you have something else, but I mean,
No, there's something along the.
That's it? Okay. Ms. Liggins, I'm going to find that there's no probable cause to go forward. However, it's very possible that they go have this case indicted if they get more information, so you need to be on the lookout. It's very possible that a warrant issues. Do you understand? Take a seat for me, ma'am.
There's now.
Judge, two no page third.
Okay. All right, is it Tizeno? You speak English, sir?
Yes, sir.
Mr. Tizeno, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
May 25th, 2026, officer observed a vehicle continually straddle to the left and right lane and continually weave within a single lane of traffic, causing other vehicles to slow down and move to other lanes. The vehicle was accelerating and decelerating from speeds within 55 miles per hour and 66 miles per hour. The vehicle also had a defective license plate light and an object hanging from the rear view mirror obscuring the windshield's view. A traffic stop was conducted. The defendant was in the driver's seat of the vehicle, and the officer observed glossy eyes and a strong odor of alcoholic beverage from the defendant's breath. The defendant admitted to consuming one margarita. Standard view sobriety test results include 6 out of 6 HGS, 7 out of 8 walk and turn, 4 out of 4 one leg stand, and the defendant provided a breath sample with results being 0.142 and 0.132.
Does he have any prior guys? Does he have a license to drive?
He does not have any prior DWIs, and I am checking his license right now, make sure it's eligible.
Sir, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds for you. Do you understand? You will be tested for illegal substances, including marijuana. If you test positive, it's not going to go well between us.
He does not have a license.
You're not allowed to drive unless you have a valid Texas driver license and liability insurance. You must maintain car insurance, and that is also a condition. If you don't have it, do not drive. You understand? Do you have the ability to hire a lawyer?
Yes. No. No.
How do you support yourself, sir?
I work.
Great. Doing what?
I'm a commercial woman.
Okay. How much money do you make a month?
Yeah, pay by hour. I rate by hour.
On average, how much money do you make a month?
At least two.
And who else do you support? Do you have any other household income?
My mother and my baby. I'm not going to.
Deputy will give you an application. I need to know everything about you, who you live with, what kind of income the other people that you have that live with, and I'll take a look to see whether you qualify. We don't give out court-appointed lawyers like it's candy. You have to qualify, meaning that you're at the federal poverty guideline.
Okay.
Don't put zeros, otherwise I'm going to send it back to you. Do you understand? You will meet with Veronica for your bond conditions. Do not use alcohol or illegal drugs. You understand?
Yes, sir.
Okay. Come on.
Lopez. Judge, this is Lopez on page 14.
Is this the last one?
Yes, sir.
Mr. Lopez, you were charged with terroristic threat. Oh. Mr. Lopez, do you have a lawyer today? Does he have a lawyer today? Does he have a lawyer?
No.
What have you done to look for a lawyer?
Can you give me some time so I can
Yeah.
find an attorney?
We will give you another reset, but your case is getting old. Have one by the next reset, please. We will have you head on over to Ramona. We'll have you sign a reset. And when you come back, please have a lawyer. Thank you. I'll speak louder. I'm light training.
Judge, how much time?
Still no reset. THA. Yes. Crazy, right? Hi, are you ready?
Morning, Judge.
Please, come on up.
Oh, back.
Okay, what's your cost number?
It is 262.
Okay.
1343.
Okay.
Mr. Regan, you were here to submit your name for his arraignment. He and his mom want to plan to park for a couple days, and I wanted to.
Not a problem, just
He doesn't have geographical restrictions, but he does have random testing.
sure.
So I wanted to see if it was okay. He could be excused the days he's out and then tested.
How long is he going?
I think it's 5 days, including Saturday.
So yes, but tell him that we have a test that goes back, not to use. If he does, then he will go to jail. So I don't care where he's going. I don't care how festive it is. Just not to use. Yeah, just, and we'll waive it. Signature. Yes, ma'am. Okay.
Okay. Okay, thank you.
Here, you have another ring? Yeah, for sure. Hey. Yeah, of course.
I have a Zapata Junior, our Liberty County guy that just still had
So, do you mind, we have Sabata who's on the docket. Now, I guess what I'm going to do is I'm just going to issue a warrant because we just don't know when he's going to get out, but at least that way we'll put the hold. And then if you want to stay on it, you can. If you want to withdraw, you can withdraw. You tell me.
No, I'm gonna stay on it. I like it.
Okay. Okay. So, can you tell me when is he evading prior to, or is
Who's an MHA?
so?
The lady in 2024.
Do you know if anything happened? Can you see a disposition on it?
Yeah, let me read the history.
So, 2501. So I'm just going to 2501. And then I guess we'll see. I don't know. That way they don't have to keep bench warranting it and you just last on the docket. About that? 2501. He's in Montgomery County Jail. And we just don't know when he's going to get out.
I don't see anything other than that.
Okay. I guess we'll just give you a heads up when we end up getting it.
Thank you, Judge.
For sure. So you did get a phone call. Yeah, if you get any more, just let me know. And then I'm going to start writing the phone numbers down and then I'll give it to the sheriffs.
Okay.
You say Sampson? That's Thompson. Ms. Thompson, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
May 25th, 2026, officer was dispatched in regards to an assault. Upon the officer's arrival, the defendant was hysterical and irate. When her parents walked around the rear of the house, the defendant started to speak louder and did not want the officers to speak with them. The defendant's father stated that the defendant was upset because they cleared out her items from the garage, which is when these defendants started to throw items all over the backyard. The defendant's mother stated that the defendant started to throw items on her father and threw the lamp. The defendant then grabbed a brick but placed it down, then grabbed a wine bottle and told her father, "I'm going to hit you over the head with this." The defendant was told to remain outside the residence, but she said she had to leave to go to work and that she's going inside and the officers cannot tell her what to do. The defendant had walked away from the officers and attempted to walk through the back door of the residence. The officers grabbed the defendant, who did not comply and resisted. The defendant was placed in handcuffs, then she dropped her weight, causing officers to have to pick her up and place her in the back of the patrol vehicle, and she then started to kick the back door of the patrol vehicle.
Was she under arrest?
I believe they were still conducting their investigation when she was told to wait outside, which is when this had all started. But it says here, gives you the information that the caller gave dispatcher about the defendant was assaulting a family member and grabbing a brick and throwing all items on the floor. The officer believed a physical altercation occurred and one of the defendants separated. And at this time, they did try to place handcuffs on her.
The information says, did then and there unlawfully with criminal negligence, namely entering a residence during a criminal investigation after receiving instructions to refrain from entering the residence, interrupt, disrupt, impede, interfere with. I thought you said did he tell her to go into the house?
It looks like they had told her to they had told her to remain outside and then she had proceeded to go inside. Which is also what the charging instrument alleges happening, to refrain from entering residence.
Ms. Thompson, I'm going to find that there's probable cause. I'm not going to put any conditions on your bond. Just be careful, ma'am. All right. Do you need a lawyer?
Yes, and
Stop. Don't. I'm going to give you a lawyer. You will with a lawyer. Because the problem is you have the right to remain silent. If you say something, they're DAs. They're going to try to use it to prove your guilt. It's just, now's not the time. I'll give you a lawyer today. Tell everything to the lawyer. The lawyer can fight for you to try to do what they can. Okay? So, yes, I'm trying to help you. I'm trying to protect you from saying something that you don't, Right. So let's do this. I'm going to have you sign a recent with Ramona. We'll have you take a seat. I'm going to find your lawyer, and then here momentarily we'll have you talk to the lawyers. Okay? Please. One second. One second. Clearly, that's a mental health crisis. You know what I mean? And they just arrest. I'm sorry, Carlos.
No, you're fine.
What's up, man?
Your Honor, Mr. Castillo and Lace Castillo.
Okay.
We have been in the process of PPI. I believe we submitted the last notice. I think they're waiting for. So we're going to ask.
We have our deputy chief right there. She'll give you a response now. This deputy chief right there. I bet you she'll give you a response right now.
Yes, sir.
If you don't mind just asking that way, is your client here?
Yes, sir.
Right. So if she says yes, we'll send her for TRAS now, and then you're in the home stretch, you know?
All right. So
Just if you don't mind, just ask. If she says she more times, then I'll give you a couple days.
thank you very
Yeah,
much, sir.
for sure. Hi. Yes, ma'am.
On client board, was reporting on Friday afternoon.
Okay.
On the connector board, and we also got a family, it's one of the film for Judge Fleischer, allow him to live in like a home because the complainant is no longer living in the full.
Do you have a cause number? Please.
Yeah.
What? Hey, Veronica, we look into Gaunt. They found two BVRs. They look like they're identical, and then they never sent an email. Do you mind just looking? Okay, what is it? 2026.
3096.
Nope. That's too many numbers. Maybe take.
I have the family law contract.
No, I need the criminal number. Or if you have a spin, maybe. For that one? No. It's a different case.
Okay.
Okay.
2629.
That sounds better.
Okay. 0730.
Wait, 073. That's it. So he's got 2 counts of assault of a family member, right?
Yes.
And you're saying the complaining witness does not live at that house anymore? Okay. Have you been able to verify that? I think this is your case, right? Yeah. Horn? Okay. So today's her first day. She's getting caught up on everything. If we verify it and they're able to determine after speaking with the complaining witness that they're no longer there, then I'm happy to do it. But I'm not going to take their word for it. I need them to verify it. And once they do, then I'm happy to do it for you. And we can scratch that provision. Yeah, so. Sure. Yeah.
Am I supposed to call?
Yeah, I mean, we need to.
Thank you.
Yeah. Mr. Bell, you ready?
Yes. You know, all
OL, right? Okay. Okay.
I believe we wanted her to check in, see if she's looking for jobs. She hadn't looked at jobs, she applied to some places. And received an interview, that was 2 weeks ago.
Miss Alford, come up. You have had 14 days and you've done 4 applications. It needs to be 44, not 4. You will have another 2 weeks. If you don't have at least 25 in by the next 2 weeks, it's not going to go well between us. Do you understand? Okay. See you in 2 weeks. If we don't have it, it's not going to go well between us.
Thank you.
All right. Thank you, Mr. Bell.
Yes.
On Miss Holford, did I say no alcohol and no illegal drugs? Please. Okay. I'd like to test it in the next few please.
It doesn't look like a big. Yeah, that's.
Hey,
It's not the club, man.
okay, is she gonna send an email or no?
There should be one still up that is,
Give me one of those BVRs.
So what you guys are saying is just duplicated data left.
Got it. Okay, thanks. Okay. She's not living there anymore? No. Great. Okay. Then, I'll go ahead and amend it. I need the cause number again. I have to write it down.
Oh.
Oh, do you have it? Yeah, what is it, please?
11-073. And I have the new address as well, if you want to, I don't know if you want to see.
Yeah, I guess he's gonna file a new one. Oh, well, he's probably not here. So what I'll do is I'll print this out. I'll take that one out. And then if you want to put it on a sticky, because I'm live streaming so it doesn't go over the entire thing, then I'll manually write it in to the other one. Yay or nay?
Yay.
Yay. Wonderful. So we'll send it for a walkthrough, and then we'll give you 2 to 3 weeks to finish it up.
Thank you, Judge.
For sure. Is that one? Yeah. Thanks. Sebastian, you ready? Hey, good morning. What's up?
She didn't make it up, that's why, go over there and talk to her, but, I just signed on last week.
Did you say Baker?
AKJR.
I don't see it.
In the jail docket.
Oh, I see it now. Okay, it was.
So I just, the age of the gate, it's an older.
Dang,
case.
it's old.
Right. I just signed on to it, last week, but, she didn't make it up for some reason today, so I had to go chat with her, but.
I bet that they're. Let's see what else she has. Okay, so she picked up a felony case.
I signed on to her once she got.
Do you sign on to the felony cases as well?
I just signed. That was a 20 felony, but.
Okay. Whatever if you want to set it. The
Yeah, I
next.
mean, as far as I understand, it's always complete and everything, so I'm assuming it's just I think the clock.
For sure. Yep. Okay. That was at the bar.
Yes,
Okay.
so it's gonna be, the survey is completed.
Yeah, he's just going to reset it because she didn't make it up. Maybe she's still in processing for a while.
Okay.
I don't know. So, great. Veronica, on Gaunt, the defendant does not have a lawyer, and the supervising officer did not send an email. I'm looking at the signature, and I have no idea who that is. Can you find out, please, who's supervising officer so I can attach them to an email asking them to reach out to him to let him know to come on Friday? Please.
Yeah.
Okay, what is it? Ah. Is it last name first?
It's, so it's
I got it. Is it Ashley dot? Right, I'm going to CC you on this in case I get it wrong. Okay.
I said
Okay. It's okay. I'm sending an email now.
Korean? Yes. No, the date I found no, was it just violence and thing? No, it's not like March. Is that what checks it? Was it done? No. It's still. You're on the record. I was. You can send a message, as soon as they. So, at 3:30, I think it has something, and we're gonna buy this. That's the only reason why that's so fast. Giving a puzzle out of this. You have something, and that's, do you mind just. Order, and I'll just do that. Yeah. Okay. Writing it in. I like to listen to the community, but I'll see like I just you Really? I was there for thank you.
I have it right now. I'm doing it for you. So here, if you want to come, that's that, and then.
Thank you.
And then, have the state line as well, Judge,
Oh,
have the state line as well.
yeah. Do you want to? Do you mind? I guess that's a good idea, just in case.
Aaron.
Just initial like where I did. And
Thank you.
So what the findings in the list.
that's just. Anyways.
Did you see what they found? Assault by biting. That's everything is watch them first. And they have this result. For sure.
Hey, Colin, can I talk to you real quick? A motion to amend the indictment for information was just filed on your client meet MS. Did you know about this? Yeah.
It's right here.
They were on their others?
Yeah.
Yeah. Yeah, so it's gonna be your signature one.
So they're adding on the 0.15.
Did you know that?
No, that's fine. No.
Okay, so here's.
What are we doing? But if he's thinking of 50 days. But it's a 90-day minimum, right? So they're abandoning the Berg Habs, but they're leaving in the 0.15. Okay, because then that would make it just a solid year, right? And then he could plead to the 50. Right? If they kept the Berg Hab in there, then it's a 90-day minimum. Okay. Do they? Who's?
No, we talked. If I talk, I'll clear.
Farwell.
I clear.
Can you talk to me? I guess I should have had you up here. So you filed a motion to add the 15 to Nate Ellis's case. I guess where Logan did. Looks like Logan filed. Did you talk to Logan at any time?
No.
Yeah.
That's strange. I didn't. Okay, so I didn't know about that. Like.
So on Meet LS. Got it. Okay. You're good with the enhancement of the Berg Hab, being abandoned.
Yes, sir.
But we're adding in the 15 allegations. Yeah.
It looks like Mr. Logan.
Yeah.
Let's see his last name. I filed a motion to amend back in March.
That's okay.
Yes.
That's what I was wondering.
The offer was already as a 0.15.
Okay.
So I thought that it was already addressed. But then when I talked to the
Okay.
clerk,
Are you ready?
yeah.
Well, no, not yet, because we don't have it.
You said it's one.
Okay. You should have it.
Okay, yeah, sure. I mean, as long as I know, I mean,
Okay, no.
you don't have to write it. I just saw it. Did you send it to them too, right? Okay. Hey, are you ready? Hi. Good morning.
This is a situation where an 18-year-old picks up a felony involved basically like weeks. He starts with this, he picks up other cases like the next week. It's now June 2nd. I'm wondering if you would be willing to offer him.
The bonds are set now.
Okay, I don't know.
They're all set at 5,002 because so he's on bond for the felony assault. Does he pick up a jail assault? Because he Oh, no. Okay, so it looks like he pleads to the assault 3:30. 7 days later, he picks up an assault. Then 2 weeks later, a mischief and an evading arrest. So he's 18. Where's he, tell me about
He
it.
has some issues. He was diagnosed with anxiety disorder and explosive personality disorder.
You say explosive personality disorder? Oh man, that's
Yeah.
far too common.
All of this is happening within like a 2 week time frame.
Who's in his life? Who's he got? You know?
Homeless.
That's a problem. Deputy Williams. Can you bring someone up? Mr. West? West. Let's talk about it.
Yeah, talk to ADA's about
Well, that's a good idea. Yeah. You know, maybe they have the reentry with the Emmett Center, at least so he can know what they have available and when. I guess let's talk to him, see what he's got. But if he's homeless and Etch, he's got a warrant. Can I go? So, is she still in? How do we know? No. It's on docket today?
Yes.
This was Bali. So she just sent you an email, or did you attach it?
Oh, I see. This is
Foster mom. I don't think the foster mom is cooperative. I'm not sure how long we're going to give her. It's been several months.
Why shit? Why?
So, the rainstorm, then I'm not going to try. This way,
And she's already? She's already? After only a month?
no, so she's having pregnancy complications. There's no lips in the case. It's just, she just having a late about it. So I believe that there's a risk of loss of pregnancy she'll be involved. She's already had it done.
Oh.
How long do you want that?
I'm always here, you know, I come in every week.
Well, are we delaying the inevitable, right? What is she, at some point she's gonna have to take care of this better now versus when you have the baby, you know, because it's just gonna be even more troublesome when that
My
happens.
position is at some point we'll have to take care of this. We still don't have a risk.
Oh. That's a problem.
The mom is, I know she's helping this. We did attempt to rip, we just haven't heard back from her, but.
Is it a Spanish rep? No. Okay. So let's set it off 2 to 3 weeks. Okay. I'm going to set up a bond for return. Because I want to know what's going on with her and then just let me know. Okay. Yeah. Okay. Yes, ma'am. Good morning, Mr. West. How's jail? What's better, free world or jail? Why do we have jails?
Yeah, it's just because we keep everybody in the system where they can get out here and listen, make a difference. If everybody can make that difference, I'm here to make my plea and plead my case.
No. Why do we have jails? We have jails because some people, when they get out in the free world, they just go crazy and they don't act in accordance, right? There's a certain way. We want our public safe. We don't want stuff broken. We don't want people in danger. And when someone turns out where they just continue to pick up case after case after case after case, it shows that there's some issues. You pick up a felony case, gets resolved. A week later, you pick up an assault. Then 2 weeks later, you pick up 2 new cases. Stop. I'm not asking you to say anything. I want you to understand why we are doing what we are doing and why we have jails. You understand? The problem is how do we go forward? Because obviously we're not going to keep you here forever. Who do you have in your life right now? Who's out here to help you out? You have parents around? Where do they live? I mean, they live here in town. Do you get along with them? Would they be willing to take you in? Why? Speak up, I can't hear you. So they just want you to follow some rules.
Yeah, but it's not even the rule. It's just I don't really. I was so rebellious.
So tell me, what's better, jail or rules with your parents?
It's all the same.
Really? So you like jail then?
I'm speaking the truth.
I get it. But is jail better than living at your parents' house with some rules?
Yeah, I think his parents also on December 3rd on his birthday. So he's been just wondering for about 3 months, and that's when he started getting that.
You know, your parents are supposed to love you forever and forever. I can't imagine that they're asking much from you. Wandering the streets of Harris County, they will eat you alive. Oh, Mom, come on up. I'm sorry, I didn't even know that you were here. How do we go forward?
Taking that step, we're going to get on the help that we need to do better. I love my son and I speak on my son every day, like, he cares. Come see me.
If she didn't care for you, she wouldn't be here, Mr. West. You know, I can't imagine she's asking much from you. Is he taking medication? Is he supposed to be taking medication?
Oh, we take anything. We have been, you know, it was a lot of things that's been going on with him that I've been taking. And I've been trying to take him to, he went to the, counseling place. I get some help there. They just see anything wrong. They just tell me just something he tried to go and do. But it escalated over the years.
Take your hands out of your pants.
And it doesn't work. And, I just didn't know how to deal with it. And, I told the city to take care of him as well. So, I put him in covered it home, to put in place because I didn't know what to do. Okay, other things happened with him. Not being home. And it's led to him being here.
So we have a mental health division within the district attorney's office. Not we, they have a mental health division. What we're going to do is we're going to try to go through them to see how we can have him evaluated and to see how we go forward with this case. We're not here to just do our worst. We want to help and we want him to leave better than he came. My fear now, if I let you out, you're just going to run amok. And that's not what we need. The last thing we need is you to pick up a couple more cases or a couple.
Is that for the most of it, the biggest goal? And then that's getting that in jail.
Wonderful. Great. Why don't we just set it maybe like a week so we can start working fast toward a resolution? My only problem is I would be happy to give him a PR bond, but the feeling is that if I let him out, I don't think you can control him. And I think that he's going to just do whatever the heck he wants to do, and he'll just start running around. And that's what I don't want. I don't want him to just, once he starts taking it, we start getting stabilizing, we start doing well, and then boom, he gets out and runs back to the same old.
Would you give them a GPS monitor with a curfew, Judge? She's willing to take on that from me.
I'm going to have my fucking phone with me. I'm willing to take.
I know, yes, I know this, but how can we get him to stay? That's the problem.
It'll be a place that will help him. I was important to do that and help wherever he has to go to make sure he's there, get it and it's there. Help.
Come up with a plan first, and then I will acquiesce to you. I don't want to just let him out with, okay, well, we're going to do this, we're going to do that, we're going to do this, we're going to do that, yet, and then nothing happens. If you have a system or if you have a plan in place, okay, we've set up an appointment at this place, this is when we're going to go do this, this is who's going to see him, this is how it's going to get, paid or not paid, because we need to figure that out as well. I'm happy to do it. We can set it 2 days, 3 days, however, but I get a lot of people that tell me, okay, we're going to do this, we're going to do that, we're going to do this, we're going to do that, and then at the end, nothing happens because they're not. So I will acquiesce you. I'm not saying no, but I want something concrete in place first, and then we can address it. In the meantime, do you mind reaching out to?
Please don't reach out to them. Our dedicated others. That's some sort of mental health.
Okay. How soon do you want to do this? So we may be able to get something set up now.
Yes, we can.
We may be, so just give us a little bit of time. She may be able to work something now where they get him into a diversion program where he'll go to the Emmett Center so they can learn and see what resources are available. And then, let's do that and let's see.
Okay.
Okay.
I'll read much.
Ma'am, thank you for coming. Yes, ma'am. Hey, Ms. Hudson. Who's first? Okay.
For general stations on the older side, a lot of over 180 days, but it's getting there.
180 is the magic number. 180 is cleared to trial. So
So,
it's 178 days. What do you want to do? Okay. So is he need a mitigation packet?
I think those in the accident, there's no accidents,
I don't believe so, but last note I have here is, it'd be a tier 2 approval decision, so.
Say it again.
It'd be a tier 2 approval decision.
Okay. Is your client here now? Can you ask him whether that's what he wants to do?
it is, we already talked about it.
Great. So I'm going to set you for a week to get the application done. And then he needs to be here, and then we'll send him for a TRAS. Okay?
I do have one more.
Okay.
Rodriguez.
Okay.
For him, he was previously denied reconsidered, but we did send in some additional information. I was only able to send in the medical information this morning, so she did let me know that she needs a little bit more time to view it. So Caitlin, the hospital,
Okay. You're at 190 days old. I'll give you until the end of the week. Shouldn't take that much longer. So, Thursday or Friday, and then, okay. Your client needs to be here as well, if it's either or.
Yes, sir.
Okay.
Thank you.
Yes, ma'am. Hi, Colin. You ready?
Good morning, Jeff.
Hey,
Good to see you, Jeff.
how are you? Mr. Haggard, always a pleasure.
Always good to be here.
Mireles, come up. Is this a true first? Good morning. So you are Mr. Mireles.
Correct.
So you were charged with driving while intoxicated. You are facing up to a year in jail and or a $4,000 fine because of the high blow. Looks like you have worked out an agreement where they're going to offer you 50 days in jail with credit for the one that you have done.
Yes.
Is this how you understand the agreement?
Yes, correct.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This DWI will go on your record. It will be there for the rest of your life. Your record, it's not very pretty. Every time you get pulled over, what are officers going to do? They're gonna look at your record. If they smell alcohol, if they smell dope, what's gonna happen? Very big possibility. The problem is that from now on, it's a minimum of 90 days in jail. Do you understand? I would never, even if you have a sip of alcohol, don't get into a car. It's a huge risk. Is this what you want to do?
Yes, sir.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I'm going to find you guilty, sentence you to 50 days in jail, give you credit for the 1 day. I'm going to suspend your license for 90 days. Do not drive until you get a license, and then we will take him into custody now. Okay. All right. Thank you. Good luck. Take a seat. Mero.
Mr. Lasca?
Laska?
Lascrap.
Oh, Lestrap.
Hi.
Yes, we know Mr. Lestrap well. How's Mr. Lestrap doing?
He's doing well. We got an offer for 30 days on the new, that case, but he's on current probation. He took a 1 year, 7 days, with the sort of probation.
What do you mean on the felony? Because it's with us. He's on probation with us.
Well, that's okay.
Continue probation on the agreement to be just a 12 months on the officials.
He took a what?
12 months, 1 year plea, 1 year Harris County Jail, 2 years if he's on probation. Yeah.
Next case, felony and 2
Okay, so I guess I'm going to match the time upstairs then. We'll give him credit for everything. He'll run at the same time. He's upstairs, you know. Yeah, I guess if you want to write it up, let's do the same thing. Yeah, we'll match what they're doing upstairs, whatever. Yeah. Okay.
We're doing for the evading. We're matching.
How much? Do you know how much credit he had in felony case?
No.
Let me see. Hold on.
As long as we're running concurrent, that's what he wants to switch.
Wow. Hey, it was a second degree reduced to a state jail. No, the theft from a person. It was a second degree reduced to a state jail. That's a big reduction. So they did give him a year, Harris County, with 35 days credit. So why don't we do 300 with whatever credit he has? That'll end up matching. Yep. Okay.
300, how much credit he has to be.
37.
I don't know. We'd have to see what he's got here. Ours will be shorter than whatever's upstairs anyways. So did you see Henry's new one?
Sure.
Did you see Henry? Ginny, Urbana. It's sweet. That's what dreams are made of. He posted it on Facebook. It's wonderful, man. Oh, about Delph, yeah, he was such a great guy. I mean, he's just everybody loved him. He'd come in all the time, say hello, and you know, just go ahead. Three little girls. That's right.
We're good to see this.
Yeah. You guys all right?
I think they say something over here. I'll see you later.
Yeah, take care. Mm-hmm. Dude, no, because you got to do it rest and do Thursday. Yeah, it's an old game. Thursday. They appealed it. They appealed it a while ago. They're just waiting for the thing. Hey, don't. They're having a conversation. You don't need to be in it. Please. That's the second time I've told you. Hi, Mr. Cunningham.
Totally off topic.
I'm live streaming, just so you know.
You what?
I'm live streaming, so that you know. Do you want to talk him back?
No.
How are things?
I need to scan the document to the USB.
Can I scan it and email it to you? Is that okay?
Scan it and put it on.
Let's go look. I don't know. That might be, and then one is going to appeal to.
So now that you can take. Some of your guys.
Which one is that? Is that the interview? No. Ramona.
Yeah.
She's a BPO.
Then you were thinking possible. Okay. We have any more?
No.
No, last one's just that one.
Okay. I legally accidentally, yes. Yeah, accidentally. Okay, then, yeah, if you don't mind, print that out. Or just save it, or by chance? We'll just print it out so we can have ready. So long as it show up for now, then it gets voted. No, she got BDR, it's supposed to be here. Okay, hi.
Good morning, Judge.
Good morning.
Good morning,
Good morning.
Another,
Recently.
pre-sign? Okay.
This
Wow.
was actually a refusal now, but recently.
Well, it is what it is.
They're on locals, so we're resetting for locals after to July 15th. So this is just.
So not eligible. Oh, yeah, they've not made phone. Okay, all right.
Thank you.
Yes, ma'am.
Guys, my name is.
What? Okay. No, let me go. Yeah, tell him just give me 1 second and then I'll take it back. Yeah. Hey,
Hey, Judge, how are you?
what's up?
Approaching on an off-topic matter.
Give me your cost.
Cost number is 2610614.
Okay.
Approaching the modified bond conditions, Judge. You had ordered him to get the interlock device in his vehicle. On that day, he told you apparently that he didn't have a vehicle to put it in. You ordered it anyway to get it within 7 days. Tomorrow is the 7th day. He doesn't have a car, so.
Well, you picked up a DWI.
No, what I'm asking is, if he didn't have a car to put it in.
Whatever vehicle he picked up at the DWI.
Oh, no, that car is scrapped apparently. He said he scrapped it for parts.
Great, but we don't have proof of that and I can't take his word for it.
Well, my question for you is, can we do a portable device?
But this, the problem is that he may still have the car and I don't know.
Okay.
I need more than just, by the way, I don't have the car anymore.
Well, he told you on the day apparently that he didn't have a car.
Yes, I'm not disagreeing with you, but a lot of people will say, I don't have a car, and then they pick up yet another DWI.
I
That's the
understand.
problem.
My problem is that he's not gonna be
If
able
he
to.
scrapped it, bring me proof.
Okay, but he's not gonna be able to do it by tomorrow. Now,
That's a problem because that's a second bond violation for him.
what was the first bond violation?
I want to say, or maybe it was a different person where,
This is a brand new case. He got conditions last week.
Right.
so they're going to file the BVR, and I'm going to put him on the docket probably for Friday. So he's got to be here at some point with some kind of proof that he no longer owns the car.
Okay, can we hold off on the BVR filing to Thursday? I'll be back on Thursday.
I mean, if he's... Say it again?
I won't be here tomorrow. That's my whole thing. I'll be back on Thursday here in court. So can we hold it tonight? Just put him on the docket for Thursday?
For sure.
Yep. And then bring him here,
Yep.
and then you're on.
Yeah, yeah.
Thursday. That's fine?
Yep,
Okay.
but his just telling me, everybody tells me everything. Everybody tells me I've got hair like both of us. You know what I mean?
Well, you got
And
one
then-
ready.
Well, maybe a couple strands.
On he's trying to get your license.
Damn, I'm tripping. Hey, come on. Good morning.
Good morning. This is on Mr. Hernandez.
Okay.
Hernandez Villarreal.
Oh, I see it. Okay. Tell me, what's up?
So this is the case that's being treated right upstairs.
The judge is
Okay.
always like, big crack people.
Upstairs, so as soon as he gets transferred to the new court, he's ready to take the deal. And it includes dismissal of his current case here in this court.
When?
Those are the ones you cannot have or you can.
Right now, there's no date.
Right. When's the next court date?
And this case is 4 years old.
I've been on the case since February.
How on earth can it not have a date?
I don't understand the mechanism. It's been transferred from unfortunately.
This is 4503. This is the next code. I know that's not real, it's just a placeholder. Correct. But he got this off on yesterday.
So what's reasonable? What's a reasonable timeline that we put on the case? You know, that we say either done or done, you know? What do you think?
I don't know if this is close. Something about it.
But all it takes is one judge signing the transfer order, and that's it, really. You know, and well, no, I don't want you to do that. Because I don't want, you know. But at some point we got to put. So I'm asking, what's reasonable? You
I
know.
would think 38. I'm not including. I'm just throwing a number out.
I mean. So your case, you've been on it for 4 months now, right? Okay. I'm going to give you a 45-day trial date where if it's not done within 45 days, I'm putting him to trial. But it's through actions of his own that this case has been open since 2021. And because by then you'll be nearly at 180 days here. Right. I mean, at that point.
That's fair.
If it's not done upstairs within 45 days, if it gets done earlier, then they'll off docket dismiss it here, and then you don't have to worry about it. But if they have it transferred within 45 days, and I mean, it really, then just who knows when they're going to do it. They're just. So, pick a date. Yep. Okay.
Yeah, real question.
What's up?
So for the bond case, my only question, Your Honor, is can we extend the end date or due date? This
He
will be
needs
done by
to be
tomorrow.
here.
Well, no. You want him to get it done by tomorrow, 5 p.m. If not, BVR gets filed.
Correct.
My question is, can we extend the end date from tomorrow, 5 p.m. to Thursday, 5 p.m.? That way the BVR never gets filed. So what I don't want is, if a true...
So, no, that's not fair. If a person has a BVR, it needs to be filed because they've not complied with the bond conditions. Because then if they have a second BVR,
That's my...
then it's, no,
That's
then
my
I'm,
concern is I don't want the ever second BVR.
but if he has a BVR, it's got to be filed because it's only fair. I cannot treat you differently than I would treat anybody else. If he has not done what he's supposed to by a certain date, then a BVR gets filed, and it happens with every single case. And I'm not going to, so
If I email...
we will still talk. I'm telling you, we can talk about it on
I just
Thursday.
want BVR to be filed. That's my...
But if it is a true BVR, then it's got to be filed. Because then what's going to happen, like what happened on the other case where, you know, well, it wasn't a true BVR, but it really was because he didn't get it done within the time that he was supposed to, just like every other person.
I hope we're not talking about the other case. That one was different.
I get it. I understand. And I didn't hold it against it. But, right. But I mean, if it's a true BVR, it's
Right.
got to be filed because you cannot continue to have issues and expect good things to happen.
Okay, so then so as soon as I walk out of this court, I'm gonna have...
Don't commit me. I don't want to commit to anything.
Well, you want proof, is what your order requires. So if he sends me proof that the vehicle was sold with the same VIN number and all that kind of jazz, if I send it over to
If he brings me something on a bar napkin, we're going to have issues.
That's not what I said.
But I'm saying, if he shows me, okay, I sold it to Punka City Auto for $15, and that's on a bar napkin that has a beer stain on it and it's got a cigarette burn on it.
Listen, Jeff. Contracts on the bar napkin.
But if it's legitimate,
You know who got signed on a bar napkin? Lionel Messi.
Well,
Messi got signed when he was 7.
homeboy's not messing, huh?
He might be. Give him a chance.
If it's legitimate and it looks like it comes from something that's
A striker.
right, then we will address it at that time. But
Well, I've already got him on docket for Thursday.
great. If he doesn't get it done,
I'm ready to send him like this afternoon, tomorrow morning, so that the DVR never gets filed.
that's on you. But we still need to talk about it because
He's on docket for Thursday.
regardless, he's supposed to have it on by a certain emergency time. If he hasn't had it on and he waits until the last second to address it, that's on them. So you can't.
He called me on Friday about this, and I told him as soon as you make your first payment, I'll sign on to the case. I'll get it started. So he made his first payment yesterday. Now I'm here.
I get it. Okay.
So, okay.
Okay.
I'll get her email address and I'll send that information to her.
Okay. But if it's not done in time, a BVR gets filed, just like with everybody else. Sinead, are you ready?
Yes, good morning, Judge. How are you?
Hi, good morning.
I'm here on J.B. Wilson.
Wilson.
Yes, Judge. And Ms. Wilson the state is accepting a PTI on Ms. Wilson. She was delayed in getting me some of the information. I just wanted a week or two to put it together and submit it to the DA's office.
Sure. Okay. Your case is 160 days old, so you're getting up there.
I understand. I plan to have it
2.5
resolved.
weeks, but at that, there's no more waived appearances, okay?
I appreciate that, Judge.
Bear with me a second. I'll get you a date.
Sounds good. Thanks.
No. Help them. Just have that first.
Just to be clear, we would consider a PCI with the mitigation package.
Oh, you would consider.
Yeah, that's what I have in my notes. There was never an agreement for it.
So did you heard that, right?
Yeah, I heard that, but the conversation that I had is that she needed to just submit it, and I'll confirm with the state judge, but I'm intending to submit it anyway.
So this is your case file, right? Okay. Bottom of page 33. So 2 to 3 weeks must appear. They're applying for a PTI.
Okay. June 18th?
That's perfect.
Okay, it's yours.
Alrighty, thank you, Judge.
Okay, yes, ma'am. Have a good day.
You too.
You too. Anna.
Good morning, Judge. I'm here on Garcia. He's on today's jail docket.
Garcia on the jail docket. Tell me, what would you like to do, Anna?
Well, so his misdemeanor was set for trial on the 30th, June 30th, but he's picked up a new case.
Oh, Lord. So I'd say we still go, right?
Okay, that's fine. I just didn't know if he wanted to do anything else with him.
No. Just because he picked up the felony doesn't mean anything. We'll still go. He's just in jail, though. You know.
Okay.
I guess I'm going to end up revoking the bond as well, though, because he picked up a felony case.
Well, I was going to ask you to do that anyway, so he gets credit. So,
Deputy Williams, do you mind bringing up Mr. Garcia? Garcia, please. Guys, you ready?
Yes.
Talk to me while we're waiting.
You're on Shannon Ball.
Okay.
And
It's only 64 days.
Yes, I was approaching for her bond convictions. She has the interlock device and the portable device.
Okay.
Right now.
Sure.
I spoke with pre-trial and she said that she's in full compliance, so we're just asking to see if we can get that portable device removed.
I don't know. She has a BVR. She had a BVR. She tested positive, right? So, I have a. We have alcohol in the car.
Yes, there's an open container of tequila in this hospital.
What was? Did she take a breath test or blood test?
Yes, there was a blood test for 4.3.
Yeah.
Okay.
Sorry.
Contact.
I know.
Contact.
Thanks.
Thank you.
Just so you know, you're not here alone. Your lawyer is here with you. If you look on Zoom, she is right there. So you, Mr. Garcia, are on bond for an indecent assault, or I'm sorry, an indecent exposure. You were set for trial when? June 30th of this year. You have now picked up a new case, a felony assault of a peace officer. I'm now going to revoke your bond on this case, and I'm going to set it at $5,001. We will still keep the original trial date, so we will put you to trial on the 30th of this month on the indecent exposure, but you cannot pick up felony cases and expect. Do you understand? Okay. So I'm assuming from now until the trial date, your lawyer will come and chat with you so you guys can get prepped on the trial. Do you just want me to set him for that day? Do you want me to set him earlier, Anna? You tell me.
Can we leave him?
To talk to him. I'm cool with it. So.
Okay, well, can we leave him on the 30th, and I'll go to the jail and chat with him sometime this week.
Okay.
And then if we need to adjust, I'll let Victoria or Ramona know.
So be ready for trial, right? Yeah. Okay. Okay. Or I guess it's not yours. It's, yeah. Got it. Okay. All right. Thanks, Anna.
Thank you. May be excused.
Yes, ma'am.
Okay. Have a great day.
You too. Take care. Bo.
Hi, Judge.
What's up, man?
Not much. I have a Mr. Aparicio on your docket today, Your Honor. I was asking for a reset.
Your case is 190 days old. I need to know what you want to do, man. Clear trial.
They just made an offer, Your Honor, so we can set it for a plea. My client said he'll take it.
Okay. We'll give you a couple weeks.
Okay.
Hey. Anything? Give me a second, Bo. I'm gonna get.
Yes, sir.
So that's like why.
Because they said it then. Hey, so on Aparicio, just two weeks, 2.5 weeks. Wait, set it for a plea, 3 weeks. Yeah. Bo, are you good with the 18th?
Yes, sir.
Okay. Your client's got to be here, okay?
Yes, sir.
All right, man. Have fun.
Thank you, Judge. Good seeing you.
Hi. Thank you for being patient.
Yes, sir.
We had a lot of people waiting. So, what's up? Mr. Sweet, come up. I guess you don't get the message. You're now on your third bond violation report. I have let you go over and over, and we continue to have bond violations. If I let you happen in 2 weeks, I don't care. You have bond conditions, and it's a third bond violation report.
Information. Even though it's technically a third, it's really not, because the last one, remember, it was confirmed that the device
Okay, sure.
was malfunctioning. And we on the first one, remember there was an issue with you just not being able to put the device in the vehicle because the wife works for CPS. So she drives clients around all day, and so that was the issue with that. So technically, it's first.
We continue to have issues with Mr. Sweet over and over and over. And this case is really only 50 days old. And it's just over and over.
Well, I guess that's the point. You really not really have issues. Now this is really the first. The other two were we. I actually remember when I was assigned to him, he was trying to kind of explain that situation.
Mr. Payne, let me ask you this. When he picked up the DWI, was it in the wife's car?
No, sir. It was in the rental vehicle.
I asked for proof of that, right?
No. At one point, and then that's when we had she had a discussion, and because the asking for proof was to give him something other than a quote. They said they will find what a spread, but at that point.
But I want to know with 100% certainty that the car that he picked up the DWI was not the wife's car. My concern is that I don't want him to have access to any car that doesn't have an interlock on it. So if he picked up the DWI in the wife's car, I'm going to have issues.
Right. Well, there was this vehicle had Colorado license plates, so.
Which one had Colorado license plates?
The vehicle that he was arrested in had Colorado tags. So his wife was out resident of Texas. But if I had known, I could have had that information for you a while back. But once we kind of came to the consensus that you would allow scram, that's the only I did. I would have presented information for it. So if that's the issue, then that's on me, because I was aware that I needed to provide at that point.
I want 100% proof that the DWI he picked up was not the wife's car. Number one. I'd like to send him for a drug and alcohol test now. Mr. Sweet, you know, I have children, and my children drive me absolutely up the walls. And when I tell my son, don't do something, and he does it, and I say, don't do something, and he does it a second time, I say, don't do something, and it happens a third time. when I threaten him with punishment and then I don't take on the punishment, what do the threats mean? They mean nothing. I'm never going to have this discussion with you again. If you ever have another issue, and I don't care if you are 1 minute past, if you're 2 minutes past, I don't care if there's a unicorn out there or Jesus tells you to do something different. If you ever have another violation, it's not going to go well between us. Do you understand me? I don't care about excuses. I will protect my community at all costs. If that means throwing you in, you understand me. Okay? I'm going to send him now. I'd like to also know, so we'll set it for Tuesday for another hearing to see about what happens with the test. But I would like by that time to know definitively whether the DWI, the nature of this case, was in a different car than the wife's car. Because the idea is that any car that you have access to has an interlock on it. Do you understand? Take a seat, Mr. Sweet. Hi. Good morning, Mr. Burns. You ready?
Yes, Judge. The motion for return of property in your jail was considered considered. In case that had been dismissed and the state has not objected to it.
Is it a gun?
It is a gun.
Do you have proof that the gun is their gun, though?
I was submitted to the state. I was submitted to you.
Who looked at it? Ms. Batista or who? Was she able to verify that the serial numbers matches and everything?
I previously submitted to the state, but I'll do so again.
Just make sure that, because I've given back property to the wrong person before, and then I had people come here just.
I imagine what nightmare.
It was a true nightmare. So that's why now I make sure that I don't have a problem giving it back to you, but I want to make sure that the person who owns the gun is getting it.
I'll do that right now. Thank you.
Please, thanks. You too. Hi. Good morning.
I have 3 people on docket today.
Okay.
Can we start with William? She's here. She's on bond. She needs to sign her bond condition.
Okay, sure. Anytime. No, I guess when it kind of dies down, we'll just have her call her up. They're bond conditions with Veronica, right? I don't remember.
Okay, and then I also have Kane.
The conditions are don't go. The theft. Where was the theft from? This is your case, right?
Yes.
So, did you draft conditions on this?
I do not believe. I do have the magistrate's bond conditions.
Okay, so here we go. Right, let me make sure she signed. She's got it signed. It says here, don't go to any Bath and Body Works, and then no going back to La Toxica.
Okay.
Right, she's got it signed, so you're good.
Okay.
Yeah.
And then I have Payne
Jail or bond?
in jail.
This is the case we had set here last week. The state wanted time to evaluate the case to see if we could possibly make it after the complaining witness.
I just did a few attempts were made again, and there's still no answer for the complaining witness. So my position is dismiss or we're a second trial today.
But we can go with this. Because I did take over the case, so he's talking about
I mean, we're gonna set for trial. Set for trial or dismiss it. I mean, there's no complaining witness.
Okay. I guess
So
just when we get done, I guess if you don't mind seeing, just eval it without it. You know.
I emailed him, he's gonna talk
Okay.
about the case.
okay, because this is I'm gonna take the trial date for.
I'd just like to discuss it.
Okay. Yeah.
Okay.
She just needs a couple minutes.
If I need a trial date.
You got it.
Mr. Mon.
Of course. I'm okay.
Thank you.
Sure. Of course.
All right, and then the last
Last.
person that I have on docket is Mr. Ramirez. He is in jail.
Okay. So essentially, if you're not going to dismiss it, they're ready to set it for trial today. So it's
Yeah.
either all or nothing, basically. So Mr. Ramirez.
Yes, can we get a probable cause?
Sure. What, it's a resisting.
This is Robert Ramirez.
So on both or on which one?
They came out of the same transaction, so it's
Okay.
the same addendums. And if we can read the actual addendums and not the summary.
I'm gonna read from the addendums. On May 30th, 2026, in Harris County, Texas, officer was dispatched to a welfare check. And in the report, he stated that a male had broken into her mother's residence and made threats towards the reportee's mother and broke into the residence. Officer attempted to contact her but was unable to get in touch. I'll read the whole thing. Just word for word, yeah. From the beginning, my belief is based on the following affiant is a certified peace officer employed as a patrol officer with police partners. I can have a good reason to believe that on May 30th, 2026, in Harris County, Texas, defendant Ramirez did commit the misdemeanor offense of failure to ID as a convicted and resisting arrest. On May 31st, 2026, affiant was dispatched to a welfare check at 7619 Baltimore Street, number 1, Houston, Texas, Harris County. Based on the call slip, the report he had stated that a Hispanic male, 44 years old, had broken inside her mother's residence and had made threats towards the reportee's mother and had broken into her residence. Affiant later attempted to contact her reportee via a callback, was unable to get in touch with the reportee. Officers on scene noticed defendant Ramirez matched the description that was on the call slip and attempted to retain defendant Ramirez, who was in close proximity to the 7619 Baltimore Street, Houston, Texas, Harris County, about 3 to 5 feet away. Defendant Ramirez was seen leaving on foot from the locations. Officer was also advised that the tendencies that defendant Ramirez had displayed during the post list. Officers on scene that attempted to detain defendant Ramirez based on his active description and due to officers' safety concerns as violent tendencies had been mentioned in the post list. These violent tendencies included threats against the reporter's mother and breaking into the reporter's mother's residence. Defendant Ramirez from multiple times chose it looking up away and stepped away from the officers as officers attempted to place defendant Ramirez in handcuff restraints for about 30 seconds. Initially,
For what? For what? He's leaving, right? So it's not can't be a trespass.
I don't believe it says he attempted to leave. He was not at the location. He was from close proximity, so he was either 5 feet away. He was some 3 to 5 feet away from the location.
So they go there to investigate whether there is an issue, right? They get there, mom's not there, he's not there. They see someone matching the description, but the person's going away. So at that point, anything that was happening is dissipated.
He was 3 to 5 feet away from the residence, and he matched the description.
Okay. She's not there, and he starts leaving.
In the description, it was a 44-year-old Hispanic male. There's a 44-year-old Hispanic male.
Bring it.
In Houston, Texas.
Bring it.
Sorry, I'm just kind of asking because there's California extradition. At some point, it's going to be mine. So, was the argument that he couldn't have been trespassing because he was already left the scene? The issue right now is.
Oh, no. We don't even know if that's the case.
Right, but that's the point, is at the time of the initial detention, right before it evolved and developed, is that they were investigating the trespass, and as it pertains to the slip, is that he broke into the the residence, and trespass, there's two ways. One is failure to leave and one is forbidden entry. And the latter is what we're arguing, is because at the time that he went for the welfare check, it was a forbidden entry, not a failure to leave. You are correct that there is nothing pertaining to refusing to leave in this fact pattern, but there is another statute in criminal trespass where he did not have permission to enter in the first place. And as it pertains to the initial,
How do you know he's even in
that's
there?
the point, is the report, assuming that is true, validated.
There's your problem.
No. Validating the call slip for the initial breaking in the residence, that's what they have to go on. They didn't have anything new in the description in the call slip, and that's the purpose of the investigative detention. As it involved to them resisting arrest and a failure ID, that still cannot be done until the initial forbidden entry, which is valid under the statute, under a different criminal trespass statute. And so you are correct. If it didn't flesh out, if it turned out the mom did permission, we would have never filed or considered criminal trespass. That's not what's being argued here. Is the initial detention as it pertains to a call slip and forbidden entry part of the statute. That's what they were investigating that developed into the other two charges. And so I believe it's valid because at the time of the stop, or at the time of the welfare check, at that point, the only information that they had was forbidden entry and that this person matched the description. That's all they need to initiate the investigation. They don't need the full end part of it until they complete the investigation, which they did, that they developed into the charge.
So, you know, when you go for a welfare check, right, you're going to see, is there someone in peril? Is there some kind of danger? Is there something aloof afoot?
Yes.
Right? You get there and everything's fine.
Sure. But we don't know that. That's the point. At the time they saw them, they didn't know.
But the law doesn't work on hunches, though.
It doesn't, and I'm not asking you. Right. At the time the officers approached, right, there's nothing stating that they've already cleared the house, that they've already spoken with the mother, that there's surveillance video, there's an independent eyewitness, there's nothing pertaining to the initial breaking in the residence that invalidated the officer's suspicion. If there was something else saying 14 different people.
What about the fact that she's not even there?
But that's the point. They don't know at the time of the initial approach. They don't have all the information, and they have a justified reason to at least make the investigation.
But he's leaving.
Yes, but
he's leaving. So
I'm not disagreeing with you, Judge. He is leaving, but that doesn't invalidate the initial detention. We are not saying that he is being arrested on that alone. That's not what we're saying. That is an investigative detention, which is permitted by law for the suspicion of forbidden entry criminal trespass. Nothing else is happening up until that point other than investigating the initial call slip for the forbidden entry part of the statute. And if it turns out that there was nothing further, then you're correct. Would have been released if he didn't give a false name, if he didn't give a false date of birth, if he didn't have an extradition warrant out of California, that would have ended right there. But then it evolved from that investigative detention into other criminal charges. And that's the distinction, is that we're not independently charging him with criminal trespass. That is just the initial reason for the stop, which is validated on DWIs, on many other things. The initial detention is not dispositive for what can come out.
What do you think?
Judge, I do not even believe that this will rise to the reasonable suspicion for the detainment. He was 3 to 5 feet away from where, in what location? 3 to 5 feet in front of the driveway, in front of the door, across the, I mean, where did
they get him?
And then also,
Where was he?
the description says a 44-year-old Hispanic male. There could have been other descriptors. My client has tattoos, so they could have said that. They're literally just said a 45-year-old Hispanic male. There are another 44-year-old Hispanic males that can be 3 to 5 feet away from this residence in this area of town. So I don't even believe that it rose to the reasonable suspicion even for the initial stop.
3 to 5 feet, where was he?
Our evidence does not specify where. It does specify that he was in close proximity to the listed address.
And if it's a neighborhood, then there's older houses that people are in close proximity to 3 to 5 feet from the next door neighbor's house. I mean,
so I'm going to interject. What counsel is wanting in terms of the full picture is not required by case law. In terms of what is provided that is sufficient for the initial detention is distinct from what would be the perfect picture of what should have happened, right? We don't have a ring camera. We don't have a full biographical description of murder. That's not required by case law. That's not required by statute. For the initial detention, it is sufficient for identifying this individual close enough that the officer made a stop. And that part has been proved. And so what they want versus what needs to happen is very different. And so the distinction is important because, yes, we certainly would love surveillance video from everywhere. We would love to have a biographical database of every person for every reason of suspicion. That's not categorically possible. There was sufficient information to identify this individual close enough for the location that the investigative detention was sufficient?
Pursuant to the court orders of the DWI judge, I don't believe it's probable cause.
Can an officer, if they get a call that there's something going on in a house, the person matching the description is there, can they go up and talk to the person?
A vague
There's
description.
just, sure, I mean, officers are free to go up and talk to whomever they want, right? They can, it's just up to the other person to decide.
That they said anything to him other than it goes from they see him 3 to 5 feet away from this residence, and then it jumps to he's being put into handcuffs.
Did they ask him or did they just find him and put him in handcuffs?
Yeah.
Was he walking while Hispanic?
Yes.
Did they just go up to him and just arrest him on the spot?
They detained, they didn't arrest. But detained,
Did they put him in handcuffs?
They attempted to detain defendants based on him matching the description.
They put him in handcuffs?
And Judge, may I read from the DIMS?
Okay, just, did they put him in handcuffs right then and there where they got him?
They attempted to detain defendants. They attempted to place him in handcuffs because of not the description in the court.
I'm gonna find no problem, of course.
They attempted to, but they didn't put him in handcuffs immediately.
This is the moment that he became violent. That they.
I was under the impression that they should get up to him and then immediately put handcuffs on him.
No, Judge. So it says that they attempted to detain him based on him matching the description of for officer safety, but at that time, he became violent. He multiple times attempted to pull his left hand away and stepping away from the officer. The officers attempted to place him in handcuffs, restraints for about 30 seconds, and that is when Officer Otero attempted to put him in handcuffs, restraints, but defendant continued to resist officer.
Did they attempt questioning him?
No, Judge.
Even
When they approached him, Judge?
No, it does not say that. It goes from officers on scene that attempted to detain defendant Ramirez based on him matching the description and due to officer safety concerns as violent tendencies have been mentioned in the cause slip. These violent tendencies included.
Let's do this. I'm going to set it for a hearing tomorrow morning. Take a look. Do you have body cam on it?
So we should have
Take a look.
Are we sticking to the four corners of the DIMS? Because based off of the four corners, there's no problem.
I want to know, what I'd like to know is did they go up and at least attempt to question him? Hey,
That's not
you
stated
know,
in the DIMS, Judge. And that's what we're basing our probable cause on. So that's not stated in the DIMS. So now we have to, if we're going to go outside
when
of
they
the DIMS
say-
and look at evidence, then that's different.
when they say detain, it means that they're going, they've stopped him, they're trying to question, and at that point, if they give false information,
I don't want the court to go in a different direction in terms of, and I understand where you're coming from, Judge, but part of the call slip as it pertains to this individual is as far as the information that they collected, it did indicate that he had violent health tendencies. And for felony stops for a myriad of reasons, and there's case law supporting this, is if they have anything in the call slip or the history of articulating violent tendencies, previously assaulted an officer, whatever that is believed for officers.
but is this a felony stop?
No, but it said violent tendencies, which again, case law has supported. If it's articulated that an officer simply is concerned by what the information is remitted to them, that it is not inappropriate for them to take measures for their safety. This is one where it's not blind, right? And this is an individual in a random.
They didn't even ask him his name. Just based off of the description, which is extremely vague, they could have asked Mr. Ramirez what his name was to confirm that was
That's what I'm asking you to.
In the office report, it does say that when they saw the defendant, he began to walk away. They began to speak to the suspect while his partner Vasquez went to speak to the mother of the caller. So they did attempt to copy it.
He said he was living out, but officers were also advised of his violent tendencies. It says officers on the scene that attempted to detain defendant Ramirez based on him matching the description. So if we're reading from the DIMS, if we're going to go outside of the DIMS, then that's completely different.
I don't know what,
I
I don't know what attempt to detain means.
Based how the DIMS reads, it seems that they saw him 3 to 5.
Let's do this. I've got a line building up. Let me get them out, and then I'll readdress it because I don't want them to sit and wait. They've been waiting long enough. Give me 5 minutes. Let me get them out, and then.
Judge, can you check the way?
But who's? Hey, who's Belinda? Hi, thank you for being patient. Come on in.
Hi.
Okay.
I have the pleasure of appearing before you.
Yes, nice to meet you. Who you got?
I'm appearing on behalf of Ms. Destiny Navarro.
Jail?
Yes.
Okay. Mr. Kim.
Your Honor, she's one out of Letitia Parish, Sheriff's Office in Louisiana for a failure to appear on a negligent homicide. I will be opposed. This is not one where this is an arrest warrant where she was unaware. The case stems out of 2023, and she failed to appear. The arrest warrant issuing out on January 2026. This is a fatality case, Your Honor, and I believe it will be appropriate.
Is it?
She's refused, and so.
Is it a life case?
No, it's not.
No.
The Louisiana statute for how it's.
I spoke to Ms. Navarro. She said that she had no idea about that she was supposed to be in court. She has been living in Houston for the past 6 months, but all of her ties are in Louisiana. She has transportation back to Louisiana and would ask for a reasonable bond so that she could travel to Louisiana and take care of this there. She has a 6-year-old child who's financially dependent on her. And does not have any issues to income.
I mean, so she was on bond for this and took flight?
Well, she had notice, which is why failure to appear. I don't know if she approached the setting, but she had notice, which is why it's listed as a failure to appear. So at some point,
I mean, it's a 2-year-old case and it's a homicide case, you know?
Yeah. It's my understanding that this is a 2B warrant. She has not appeared.
If I were to set a bond, it's going to be very substantial just because of the nature, you know?
Based on my discussion with Ms. Navarro, she has limited means.
Right.
So I would ask Your Honor to allow her to go ahead and can we file the waiver?
Sure, of course. Yeah, I mean, if she's ready to sign it.
She'll be ready to sign that.
You know, and let her know, it's Louisiana, you say?
Louisiana.
So once she waives, within the next 3 to 5 days, she'll be back probably.
Right.
So, yeah, just let her know it's going to be substantial.
All right.
Like, yeah,
If
sorry.
she signs the waiver, she has to sign it to turn the court to the sign. You don't have to read it, but she has to be the one that signs.
Okay. All right. And I have nothing further.
Okay. Nice to meet you.
All right, nice to meet you.
Ms. Batista. Mr. Burns. Ms. Batista, were you able to confirm they match?
Yes,
Yeah, okay. I'll grant it for you, Mr. Burns. For sure. Of course. Hi.
Good morning, my name is
How are you?
I am well. My client is well on docket today. He did come in voluntarily. He's happy to be in the building. Mr. and gentlemen.
I thought you were on a trip.
Not yet. I did. I went to Chicago. Well, I went to Waukegan. We went to go to the.
So you're back.
Yes, we went to the Navy base. We needed to bury my partner's grandfather's ashes. We found there. So, you know, it takes a while to get the reservations to get everything set up to the So I had to go out there for this week. Not so much party. Just a little bit of.
What are we doing with Mr.
He did, like I said, Your Honor, he did come in voluntarily this morning. He informed me that he did want to take care of this, and he apologized sincerely. So I have been emailing this morning with the DWI and Henry. And she just also emailed me, well, we've been waiting on a contract for a few hours. I've been in and out throughout the morning.
So they're going to honor the programs?
Yes, they.
Wow.
Okay.
Okay.
All right, well.
Just because the reason why that is because it's.
I'm kind of,
easier today. That's the only
but
reason why I told him.
I got to say, I'm really reluctant to reinstate his bond because he does nothing but play games. He's been playing games since day one. That's all you do is play games. You play games with everyone. You play games with us. You play games with your lawyer. You play games with everybody. So I have enough drama in my life. I don't need any more. And the only thing that gets you to do anything is when we get your warrant. It's like, come up.